United States, the great state of Florida, and its honorable court.
Please be seated. We have two cases on the calendar this morning which we're going to take in the order listed. I assume that you've all been made aware of the marvelous workings of our time clock. Please keep in mind, if you represent the appellant, that the time appearing on the clock is your total time. If you want to reserve time for rebuttal, you need to keep track of the time that's remaining. And when you get to the amount of time that you want to reserve, you need to stop. The first case is Hillsborough County School Board versus Senyak. We've allotted 15 minutes to the side.
May it please the Court. My name is Mac McCormick. I represent the appellants, the Hillsborough County School Board, and their workers' comp servicing agent, which is Broadspire. And I would like to reserve 3 minutes for rebuttal, please. Your Honors, I believe that this is an EMA issue arising under the medical portion of the workers' comp statute. That's a pretty straightforward issue, at least on these facts. I would like to briefly touch on the relevant chronology again. Of course, we have a January 2007 alleged date of industrial accident where a woman who worked at a middle school was sitting and standing repetitively from some chairs in a computer lab and alleged knee injury, more specifically a tear to her right lateral meniscus. There were some petitions filed in the summer and also in December of 2008 for compensability of that condition and medical care. The claimant obtained an IME with a physician of her choosing, obviously, on November the 18th of 2008. And the employer servicing agent received that petition both through the course of discovery and as an attachment to the petition on December the 10th of 2008. The report, and this is obviously one of the important facts in the case, the IME report noted some things about the MRI findings. There was a notation of some degenerative and pre-existing conditions on that MRI.
Mr. McCormick, if I may, let me ask you first. As I understand it, the sole issue in this case is whether the judge of compensation claims correctly denied your request for an EMA as untimely because you waited too long. Is that right? I would absolutely agree. I think the issue... And that in turn turns upon, as you were just beginning to tell us, Dr. Fiore's November 18th, 2008 report was sufficient to put your clients on notice that there was a dispute amongst the doctors. I would agree with that to the extent, was that sufficient, such that moving to the expert medical advisor after the physician's deposition constituted acting without undue delay? Was that with reasonable promptness under the case law? Well, yes, as I understand it, your argument below was that it was not an unreasonable delay because you didn't know about the conflict until after you took the deposition. Yes, I would agree with that, Judge, that if you look at the actual language of the IME report that we received in December, it just simply said that the findings on the MRI of the meniscus tear was consistent with the mechanism of injury that the patient had described. Now, obviously, the issue of major contributing cause, that's a statutory issue. That's a concept legally that's very well defined. And again, in absolute candor to the court, as I conceded in our brief, I can't stand here and say that when my partner, who was trial counsel, took that deposition or attended that deposition, that we were surprised that the claimant's IME physician actually rendered an opinion that this alleged industrial accident is the major contributing cause of the injury, the torn meniscus, and the corresponding need for medical care. Well, let me ask you about the report. Under history, Dr. Fiore says, the patient was working as a teacher assisting children in a computer lab, requiring frequent sitting and standing at their stations, when she noted the onset of right knee pain by the end of the day. And then under his discussion of the final assessment, he says the MRI findings of lateral meniscus tear are consistent with the mechanism of injury of frequent sitting and standing. Now, why aren't those two statements together sufficient to put you on notice that there was a dispute regarding causation?
Your Honor, my response to that would be that what we expected was that when the deposition was taken, that the physician would likely render an opinion on the issue of major contributing cause. But I would submit, Your Honor, that the difference between something being consistent with, that's not an opinion within reasonable medical certainty that the alleged incident is in fact the major contributing cause of the incident.
I noted the exchange in the briefs regarding who took the deposition and the comments in the brief regarding the importance of that. But here, you also didn't schedule the deposition. The claimant did. So your client didn't take that report and say, well, I'm not sure, I'm even conceding your perspective, I'm not sure whether this is a problem or not. Let's take the deposition of the expert. The claimant took the deposition.
Well, Your Honor, I don't see how the employer servicing agent would have incentive to take testimony that would obviously advance the claimant's case. What I would submit in response,
Unless you really wanted to find out whether an EMA had to be appointed.
Right. I mean, would you not follow up? I mean, let's concede your first point that the initial report doesn't really alert you with bells ringing and siren lights going that you've got a conflict. Isn't the next logical step to schedule that witness for a deposition and say, do you think this is the MCC or not?
Well, Your Honor, I think from our perspective in terms of when we are obligated to move for the EMA, it's when does the material disagreement manifest itself? When is that revealed? And my other answer to that would be, you know, if in fact the notation that the MRI finding was consistent with what the claimant told the physician, if that was sufficient.
I'm sorry, could you repeat that? That was a little fast.
I apologize.
That's okay.
If the notation in the report that the findings on the MRI are, quote unquote, consistent with the described mechanism of injury, why then did the claimant bother to take the deposition on their side of the aisle?
I understand that, and I thought that was an interesting comment in your brief, but the fact of the matter is, as I understand the issue here is, you have to convince us that you weren't dilatory and request an EMA, and I'm aware of those cases that say if the conflict appears even at the final hearing, we've held that you should reschedule, the JCC should reschedule the hearing. But here, we're looking at a situation where you were put on some kind of notice and you didn't follow through with not you, but the client didn't follow through with a deposition to determine the exact nature of that conflict, and then the request is made the day before the hearing. That just seems to be very much, if we say that's fine, that seems to create a holding that could cause some real problems with, as your opponent has noted, with resolving these cases in the 210-day deadline.
And before you respond, Mr. McCormick, let me tell you that I personally am concerned about the dramatically, rapidly increasing number of these cases that we're seeing where at the 11th hour, one of the parties comes in and requests an EMA requiring the JCC to cancel the final hearing. That's not good judicial administration. So if you would, respond to our concerns.
Well, certainly. And just in a brief word in terms of correction, the hearing on the motion for the EMA that Judge Murphy conducted was the day before. I mean, obviously it was, I believe the motion was filed
on the 17th, and the hearing was the day before the hearing on your motion was the day before the final hearing.
Right. We filed on the 10th. The final hearing was on the 18th. So it was
so 8 days before, I'm sorry.
Correct.
8 days before you filed the motion.
My response to that, Judge, would be simply, as I understand it, our obligation to move in a non-dilatory, move with reasonable promptness to ask the court for the expert medical advisor is when the material disagreement manifests itself. And our contention is that took place for the first time in terms of this clear opinion on major contributing cause in the deposition. I would distinguish.
If the claimant had never taken Dr. Fiore's deposition, and you waited, even though you had this report from him, You waited until the final hearing, he gives his testimony, then you ask for an EMA there, that would have been okay.
I'm not sure I understand the scenario.
Well, I mean, you didn't take Dr. Fiore's deposition.
Right.
So if the claimant hadn't done it, you claim that's the first notice you had of a dispute. If the claimant hadn't done that and just offered Dr. Fiore's testimony at the final hearing, you could have asked for an EMA then.
Your Honor, the way my response to that would be, it's not so much a matter of being on notice of, again, the likelihood, the suggestion in the report that the doctor believes the major contributing cause, or he's likely to render that opinion. Again, I think our obligation to move and ask for the expert medical advisor, our due diligence is moving quickly once that opinion has been expressed. As I understand the case, I don't believe that extends to once we suspect there may be a material disagreement, then the onus is on us to make sure that we do whatever discovery and take whatever testimony is necessary to ripen that.
Why isn't that a better rule than allowing a party, and I don't care whether it's the employer or the claimant, to wait until right before the hearing or at the hearing and say, oh my goodness, we've just found out that there's a material dispute here. We have had this report for months, but we just now realize there's a material dispute because we just heard his testimony. Why isn't the other rule a better rule?
I just think that would somehow cloud typically when you conduct discovery, you take the depositions that you feel are necessary to advance your case in chief, and I think to blur that line, we are now responsible to secure testimony that would certainly be offered against us, based on the other party's retained expert. I think that the idea of relying on a more equivocal report, that's just not consistent with the practicalities of how this.
You're going back to the dates, counsel. When did you first learn of Dr. Fiore's report? Was that December 10th?
Yes.
And you filed your motion on February the 10th?
That's correct.
So about 2 months elapsed from the time you learned of this report until the time you filed your motion?
Correct.
And that was 7 to 8 days prior to the hearing?
That is correct, Your Honor. It was a few days after the deposition.
Now, the question is, are you aware of any case law wherein filing a motion 8 days prior to the hearing was not reasonable under the circumstances?
I don't think there's an on-point case specifically to these facts. You've got a whole litany of law that most of the cases on EMA, the JCC that denies the EMA is overturned, and then there's a much smaller line of cases where denial of the EMA was upheld. Are you aware of any
case law where the window was 8 days or more prior to the filing, to the hearing itself, where the denial of the EMA was overturned?
No. Most of the cases where
go ahead.
Most of the time when the denial of the EMA was upheld, you have that trio of cases. The Van Slyke decision where the employer carrier moved 9 days after the order awarding benefits. In the Knight case, you have disagreement that had been apparent for 9 months, and the motion was on the eve of the final hearing. And the Gonzalez case, where the motion was made at trial.
Right. Are you aware of any cases where the denial of the EMA was upheld where the window was 8 days or more prior to the hearing itself?
No, Your Honor. I mean, you do have cases where the motion's made at the hearing, because that's when the material disagreement manifests itself. And again, our position, and I'll reserve the remainder of my time for rebuttal, is that disagreement materialized on the issue of major contributing cause at the deposition, not with the IME report.
May it please the Court, Counsel?
I asked you the same question I asked Counsel for the appellate. Are you aware of any case law where the denial of the EMA was upheld where the motion was made 8 days or more prior to the hearing?
I don't know of any cases that deal with 8 days. Or more. I know the Knight case is 2 days. And the other cases, the motion was made 2 days before. which is kind of analogous here because we're not argued until one day before. But the motion was filed 8 days before. The other cases are longer out where the motion was made. I think where the denial was upheld,
Is there any
they were
dispute
made
as
at the
to the
hearing.
December 10th date, the date that counsel indicates that he was first made aware of Dr. Fiore's report?
I'm sorry, I didn't get the first part of
Is
that
there any
question.
dispute as to the December 8th date, the date counsel asserts that he first became aware of Dr. Fiore's report?
I think it's December 10th, and I don't think there's any dispute about that. It was attached to the December 5 petition, and there's no dispute it was received on the 10th.
Mr. Questa, what's the standard of review in this case?
We maintain it's abuse of discretion. You know, the parties are in disagreement about that, but this case, as you pointed out, is an issue about whether the